1 minute. Huh? Okay. Sorry, let's go ahead. So the first topic in this is res sub judice. Okay.
Yeah.
Which is basically stay of a suit. So section 10 of CPC among stay of suit. No court shall proceed with the trial of in any court in which the matter is directly and substantially an issue of previous instituted suit between the same parties pending this in the same or in the same any other competent court.
So one more suit when the case is pending.
So res judicata ki res sub judice ki judicata ki enti teda.
So for first is it's already decided. Second, it's going to decide. It's already pending trial.
Already a court lo pending unnadani vere court lo
Hmm.
yeddu antaru. So this is basically section 10. Section 10 of CPC. The provisions are mandatory. The use of no court shall proceed makes the provision binding on the court. Okay.
Okay.
అంటే ఇంకో కోర్టుకి అధికారం లేదు ఆల్రెడీ ఒక కోర్టులో ఉన్నప్పుడు.
Okay.
So yesterday we have decided this picking up case, right? You know, if it is in district court, high court can pick it up.
See, high court cannot do trials. It's not about picking up. I think we have used the wrong terminology. High court can move from one district court to another district court. Or the Supreme Court can do it. Okay. Because ultimately,
Transfer of suits.
trial has to happen at a lower court, right? In some cases, it will happen in district courts if the value is more. Okay.
Okay. What is the section for transfer of suits? You remember?
Transfer of suits.
35 or 36?
ఒక పని చేద్దాము మొత్తం అంతా నిన్నటిదంతా ఫస్ట్ రివిజన్ చేసుకుని మళ్ళీ ఇక్కడికి వద్దాం సరేనా?
We can do that.
We will take the same time again.
22 to 25.
Same time పడుతుంది మళ్ళీ మొత్తం చేయాలంటే. Or we have to do it very quickly.
That's okay.
నువ్వు రివిజన్ ఇంటికాడ చేసుకో అర్థమైందా? డిస్టర్బ్ చేయకు.
అదే లెట్స్ గో.
10 లో ఉంటే 10 మీద ఫోకస్ చేయి.
ఓకే, ఇది కూడా ట్రిమ్ చేసేయి.
ఇది కూడా ట్రిమ్ నేను చేయ మహేష్ ఈ మొత్తం అన్ని పెడతా.
Oh God.
Okay, so res sub judice, res judicata. Let's focus. Res sub judice is basically a suit pending ఉన్నప్పుడు జరుగుతుంది. Judicata is ended. Stay subsequent suits, bar subsequent suits. Okay, applied during pendency, final judgment, plea for stay, plea in bar, suit liable to dismissal, suspends later revived, permanent bar. So res judicata is basically section 11. No court shall try any suit which is already been adjudicated. So 5 conditions which are important res judicata law, which is basically form a suit that has been finally decided on merits. I sent WhatsApp an app note. Now did you check? లేదు మా ఆవిడతో మాట్లాడుతూ. Okay. Okay, bye. I have work. Okay, go. Hello, sorry guys. So 5 conditions must be former suit that has been finally decided on merits. And the second one is a matter directly and substantially an issue must be same in both suits. The parties must be the same and must be litigated under same title. The court must decide the former suit must be competent to try the subsequent suit. So basically ఏంటంటే కండిషన్స్ ఏముంటాయి? ఫార్మర్ సూట్ కాజ్ ఆఫ్ యాక్షన్ సేమ్ ఉండాలి, సేమ్ టైటిల్ ఉండాలి, సేమ్ పార్టీస్ ఉండాలి. ఓకే, ఆర్ ద కోర్ట్ విచ్ హెస్ అడ్యుకేటెడ్ మస్ట్ బి కాంపిటెంట్ ఉండాలి, అండ్ సబ్జెక్ట్ మ్యాటర్ మస్ట్ బి డైరెక్ట్లీ అండ్ సబ్స్టాన్షియల్లీ రిలేటెడ్ ఇన్ ద ఇష్యూ. అప్పుడే దే కెన్ సే ఇట్ ఈస్ రెస్ జుడికాటా అని. Okay. The subsequent suit is
If-
liable to dismiss.
If cause of action is part of the current suit, then
Hello.
yeah,
Yeah.
if the cause of action of existing suit is part of the new suit, appudu will it be dismissed or taken?
Only cause of action with, see, multiple things ఉండాలి కదా, ఈ 5 conditions satisfy చేయాలి అందుకనే. సో వన్స్ ఆల్ ద కండిషన్స్ ఆర్ సాటిస్ఫైడ్ ఓన్లీ, ఇప్పుడు సేమ్ పార్టీస్ ఉన్నాయని వేరే కేసు వేయడానికి లేదనడానికి లేదు కదా, సేమ్ పార్టీస్ మైట్ బి ఫైటింగ్ ఆన్ డిఫరెంట్ ఇష్యూ, రైట్? సో ఇట్ హ్యాస్ టు బి ద సేమ్ కాజ్, సేమ్ parties, whether the court is competent or not, on things like that. And they must be fighting on the same issue also. So this res judicata, Darayo versus State of UP, it's an important case, 1961. Res judicata applies to writ petitions under Article 32 and 226 of the Constitution. So a matter decided in civil suit can bar a subsequent writ petition on the same issue. So ఈ కేసులో ఐ థింక్ లాస్ట్ సిపిసిలో కూడా చదువుకున్నాము. ఇస్ అ వెరీ ఇంపార్టెంట్ కేసు ఈ డరాయో వర్సెస్ స్టేట్ ఆఫ్ యూపీ. బికాస్ వాడు సుప్రీం కోర్ట్ వెళ్ళి రిట్ పిటిషన్ వేసి he was trying to open the same litigation instead of appealing on the whatever is adjudicated. So the court said, and his argument was, res judicata ఇప్పుడు సివిల్ సూట్ ఉంటే ఇంకో సివిల్ సూట్ వేయొద్దు అన్నారు, రిట్ పిటిషన్ వేయొద్దని ఎవరు చెప్పలేదు కదా నాకు, అందుకని నేను రిట్ పిటిషన్ వేసాను అన్నాడు. So Supreme Court said, once something is decided, res judicata applies to even writ petitions also అని క్లారిటీ ఇచ్చింది అనమాట ఈ గ్రూప్, ఈ కేసులో. ఓకే. అండ్ constructive res judicata. Constructive res judicata is basically section explanation 4 of section 11 embodies the doctrine of construction res judicata. Any matter which might ought to have been made a ground of defense or attack in the former suit shall be deemed to have a matter directly and substantially in issue in such suit. So distinction between regular res judicata ఏంటంటే constructive res judicata bars a plea that could have been raised but was not raised. ఓకే. సో ఇంపార్టెంట్ థింగ్ ఏంటంటే వెన్ ద కేస్ వాస్ గోయింగ్ ఆన్, నేను ఈ ఈ పాయింట్ చెప్దాం అనుకున్నా మై లార్డ్, కానీ నేను లాస్ట్లో దాచిపెట్టుకున్నా, నేను చెప్పలేదు. ఇప్పుడు ఆ పాయింట్ మీద నేను మళ్ళీ ఇంకో కేసు వేస్తున్నా అనడానికి లేదు. కన్స్ట్రక్టివ్ res judicata బార్స్ దట్. సో వాట్ ఎవర్ యూ కుడ్ హ్యావ్ యూ కుడ్ హ్యావ్ రేజ్డ్ ఇన్ ద ట్రయల్ ఇట్ సెల్ఫ్. ఇప్పుడు నేను రేజ్ చేయలేదు కాబట్టి కొత్త కేసు వేస్తానంటే దొబ్బదాను. And regular res judicata bars an issue that was initially raised and decided. These are two different doctrines, do not conflate. Okay. Regular res judicata is basically normal it was raised and decided. Constructively ఏమవుతుందంటే I forgot one point, I want to raise now అంటే it is not allowed. So there are two landmark cases on constructive res judicata with Satyanandan Goshal versus Dio Ranjan Debi. So define constructive res judicata, a matter which might or ought to have been raised as a ground of defense or attack shall be deemed to have been decided. సో ఈ మ్యాటర్లో స్ట్రిక్ట్గా చెప్పారనమాట, నువ్వు డిఫెన్స్లో అప్పుడు రైజ్ అయినప్పుడు కొత్త కేసు వేయడానికి లేదు అని. State of UP versus Nawab Hussain applied constructive res judicata. The respondent have been dismissed. He initially challenged a dismissal under Article 311, later filed a separate suit challenging a dismissal of grounds he could have raised in writ petition, held barred by constructive res judicata. Okay. సో ఇందులో ఏంటంటే ఈ కుడ్ హ్యావ్ యూజ్డ్ అడిషనల్ రెమెడీ విచ్ హీ డింట్ యూజ్. వాట్ ఈస్ ఆర్టికల్ 311? ఎనీబడి హ్యాస్ అన్ ఐడియా? I think is that arbitrary dismissals చేయగొట్టడానికి లేదు కదా, without hearing the other person.
Doctrine of pleasure.
Doctrine
It
of
mandates that employees cannot be dismissed by an authority subordinate to their appointing authority and guarantees a reasonable opportunity for fair inquiry.
Must be given reasonable opportunity of being heard. And it applies to civil servants.
Yeah, but he's a sub inspector కదా. So he has been dismissed. He initially challenged under 311 only. Later filed a separate suit challenging the dismissal on the grounds he could have raised in the writ petition.
Okay.
సో ఫస్ట్ డిస్మిసల్ ఆర్టికల్ 311 కింద ఛాలెంజ్ చేసేసి అందులో సరిగ్గా రాకపోతే మళ్ళీ రిట్ పిటిషన్ వేసిండు. సో దే సెడ్ ఇట్ ఈస్ నాట్ అలౌడ్. నీకు ఆల్రెడీ ఒక ఛాన్స్ ఇచ్చినాం కదా, ఇంకో ఛాన్స్ సేమ్ కేసు మీద ఇంకో ఇయ్యము అని. కన్స్ట్రక్టివ్ రెస్ జుడికాటా. సో రెస్ జుడికాటా ఈజ్ ఇన్ రిప్రజెంటేటివ్ సూట్స్. When persons litigate bona fide in respect of a public right or a private right claimed in common for themselves or for others. Okay, all persons interested in such right shall, for the purposes of res judicata, be deemed to claim under the persons who are litigating. So a representative suit binds all persons interesting. So it is like a class action lawsuit. Okay, ఇప్పుడు క్లాస్ యాక్షన్ రాసూట్ ఏంటంటే ఇప్పుడు ఇట్స్ ఆల్రెడీ డిసైడెడ్ ఇన్ ఏ, ఇప్పుడు ఇఫ్ ఇట్ ఈస్ ఎఫెక్టింగ్ ఏ గ్రేటర్ గుడ్ ఆఫ్ పీపుల్ అండ్ సంబడి హెస్ పుట్ కేస్ అగైన్ దట్స్ కేస్. ఇప్పుడు ఓఆర్ఎస్ కేస్ అయింది కదా, ఓఆర్ఎస్ దెర్ వాజ్ అ కేస్ విత్ డాక్టర్ వాస్ ఫైటింగ్ ఫర్ ఎవ్రీబడి saying that ORS is a duplicate ani. Now you cannot go and say okay, I also have an issue, I will fight this case. It is already decided, right? So it is like a representation where the lady did for the entire public.
Shivaranjani. Yeah.
Shivaranjani, yeah. So you cannot reopen such suits again. And then foreign judgments. Foreign judgments important too. When foreign judgment not conclusive, foreign judgment shall be conclusive. So section 13 ఏమంటుందంటే నాట్ కన్క్లూజివ్. ఫారెన్ జడ్జ్మెంట్ ఈజ్ నాట్ కన్క్లూజివ్ అంటే క్లారిటీ లేదు. ఫారెన్ జడ్జ్మెంట్ షల్ బి కన్క్లూజివ్ టు ద మ్యాటర్ డైరెక్ట్లీ ఎడ్యుకేటెడ్ అపాన్ బిట్వీన్ ద సేమ్ పార్టీ ఎక్సెప్ట్ వేర్ it has not been pronounced or it has not been given on the merits of the case, where it appears that the phases of the proceeding to be found on incorrect view of international law, where the proceedings were opposed of national justice, where it is obtained by fraud, where it seems a claim found on breach of any law in force in India. So section 14 ఏం చెప్తుంది? Presumption as to foreign judgment, the court shall presume upon production of certified copy of foreign judgment that it was pronounced by a court of competent jurisdiction unless contrary appears on the record to be proved. కాంపటెంట్, ఒక కాంపటెంట్ కోర్ట్ అయితేనే యాక్సెప్ట్ చేస్తారు అనమాట. సో 13లో 13 ఇవన్నీ 13 ABCDEF కండిషన్స్. వెన్ ద ఫారిన్ జడ్జ్మెంట్ని ఎందుకు తీసుకోము, ఈజ్ ఆర్ ఆల్ ద థింగ్ నాట్ కన్క్లూజివ్. And section 14 is presumption of foreign. Presumption enti that it is given by a competent court. So what ikkada enti, how AIB, what is the tricky part of it is which one of the following is not requirement for foreign judgment to be conclusive, with option that it must be pronounced by a court or competent jurisdiction, being the BC answer. Okay, the reason section 1 is phrased negatively listing circumstances where judgment is not conclusive. Section A excludes only judgments not pronounced by competent court. It does not affirmatively require competent jurisdiction in the body of section. The presumption of competent jurisdiction is in section 104. Okay, so tricky question ఏంటంటే what you have to remember is కాంపిటెంట్ జ్యూరిస్డిక్షన్, కాంపిటెంట్ కోర్ట్. ఓకే, ఇప్పుడు ఇందులో ఏంటి, సెక్షన్ 14లో ఇట్ ఈస్ అబౌట్ కాంపిటెంట్ కోర్ట్ అండ్ ఇక్కడ కాంపిటెంట్ జ్యూరిస్డిక్షన్. సో దీన్ని అటు ఇటు మార్చి అడుగుతూ ఉంటారు. సో జస్ట్ బి కేర్ఫుల్ అని రాశారనమాట. ఓకే, ద జడ్జ్మెంట్ ఆఫ్ ఫారెన్ కోర్ట్ ఈస్ డిఫైన్డ్ ఇన్ సెక్షన్ 2.5. ఎక్సెప్షన్స్ is basically the judgment was obtained in fraud, not in parties of knowledge. Subject matter was not actually the same, or earlier suit was dismissed with education of merits. So basically, the 2.10 లో important thing ఏంటంటే res judicata తో పాటు foreign judgments గురించి we have to learn, which is basically on the section. What section is foreign judgments?
13
and 14. 13 and 14. So section 2 is about foreign judgment is defined. Section 2 is a definition of foreign judgment. Section 13, foreign judgment not conclusive. 6 grounds ఉన్నాయి. Section 14 is presumption of competent jurisdiction for foreign judgments. So we'll get into the questions quickly, which is basically section 10 of the CPC provides for what?
Res judicata.
Section as stay. Okay. Section 10 CPC provides for stay of a later suit when the same is directly and substantially in issue of an earlier suit. So section 10 is about res sub judice. సో ఫస్ట్ ఆఫ్ ఆల్ ఆల్రెడీ వేరే చోట ఉన్నప్పుడు ఇది స్టే ఇచ్చేస్తుంది. ఈ కేసుని స్టే ఇచ్చేస్తుంది. ఇంపార్టెంట్ థింగ్ ఇస్ ఇట్ ఈస్ ద ఎగ్జిస్టింగ్ కోర్ట్ ఈస్ స్టేడ్ బికాస్ అనదర్ కేస్ ఇస్ ఆల్రెడీ రన్నింగ్. ఓకే. అండ్ విచ్ ఆఫ్ ద ఫాలోయింగ్ is not a requirement of foreign judgment to be conclusive? Okay.
Court of competent jurisdiction.
Jurisdiction. BB.
Competent jurisdiction. Okay. And the principle of res judicata is dealt under section 11. Okay. Principle of provisions of section 10 of CPC are
mandatory.
Huh?
Mandatory.
Mandatory. Okay.
Mandatory. Oh. Sub judice కదా, res sub judice.
Res sub judice is mandatory. First చూసుకోవాలి కదా వేరే చోట కేసు ఉందా లేదు.
Okay.
Constructive res judicata is contained in which of the following?
4. Explanation 4 to 11. 4 to 11.
Explanation 4 లో ఉంది. Okay. And which of the following section of civil procedure code deals with concept of res judicata? Section 11. Which of the following provisions of civil procedure code makes the doctrine of res judicata applicable in representative suits?
Section 11, expression 6.
6. 4MO is about
constructive res
judicata.
6 is class action lawsuits and representative. And which section of CPC deals with principles of res judicata?
11.
It's standard question.
Questions.
As per section 11 of CPC, res judicata to be applicable on subsequent suit, the former suit ఏమవుతుంది? Has been finally decided, can be instituted prior to.
No, I'm reading.
Read. Hello. Read it out loud.
Okay. As per section 11 of the CPC 1908, res judicata to be applicable on a subsequent suit, the former suit has been finalized, can only be instituted prior to subsequent suit, relates to the same matter directly and substantially in issue in the subsequent suit, is between the same parties or between parties under whom they are any of them claim.
Mahesh, it looks as if you're rapping.
Sare, ఇక్కడ 1, 3, 4. So second answer, can only be instituted prior to subsequent suit, is wrong.
Section 11, to be applicable is the former suit has been finally decided. Okay. 3 is relates to the same matter directly, substantial subsequent suit between the parties. 2 is not correct.
How can former suit be instituted before subsequent suit?
Okay. Yes. Okay. Fine.
It's common sense kada, subsequent suit.
Correct.
So okay, next Mahesha, keep reading.
Okay. Foreign judgment is defined in CPC. Under which section? Section 2 of 6 of CPC, section 2 of 7, section 2 of 8, none of the above. Foreign judgment 2 of 6. 2 of 6 na? 13 in the okay, that's okay. Definition is in 2 of 6. 13 where I am going to
13 is basically on the competent court edo undi kada.
Validity of foreign judgment.
Section 2, foreign judgments defined as judgment of foreign court. 2 of 6 hai kada.
13 is about validity, evaluation of foreign judgment.
13 is not conclusive.
Foreign judgment not conclusive on the 6 grounds. Okay.
Okay, section 14 is presumption that it is a competent court.
Competent jurisdiction.
Okay.
Okay.
Yeah.
All right, continue.
సెక్షన్ 2 అని చెప్పిన ఇందాక మర్చిపోయాను. 2 of
Okay.
6 ఇవన్నీ అయిపోయినాయి కదా.
Yeah.
విచ్ క్వశ్చన్ ఆర్ వి ఆన్?
2 of 6 ఎక్కడ ఉందో అక్కడ
11.
పైన. Okay. In a suit where the doctrine of res judicata applies.
So what will happen if res judicata applies?
Suit will be dismissed.
Dismissed.
ఇక్కడ ఎందుకు ఇంత స్మార్ట్గా అడిగాడంటే రెస్ సబ్జుడిస్ అయినప్పుడు ఏమవుతుంది?
అక్కడ స్టే ఉంటుందా? స్టే ఆఫ్ సూట్స్.
రెస్ సబ్జుడిస్ అయినప్పుడు అరే ఆల్రెడీ వేరే కోర్టులో నడుస్తున్నప్పుడు ఈ కోర్టులో స్టే ఇచ్చేసినామని చెప్తారు.
ఓకే.
అది డిస్మిస్ అవ్వదు. రెస్ జుడికాటాలో ఉన్నప్పుడే డిస్మిస్ అవుతుంది. దీన్ని కన్ఫ్యూజ్ అయ్యి అడిగినాడు.
All right. Section 14 of the CPC deals with presumption of foreign judgments. 13 వచ్చి foreign judgments is not conclusive. 2 of 6 says definition of the foreign judgment. Okay. Next question, rule of the res sub judice implies. Same subject matter is pending in a court of law for adjudication between the same parties. The other court is barred to entertain the case so long as first suit goes on. I think A.
What is the question? The rule of
The res sub judice implies.
Already going on in other court. The other court is barred to entertain. Okay, next.
Okay.
Q14. A suit brought by a person to recover possession from stranger of mutt property, claiming it as heir of the deceased mahant. The suit is dismissed on his failure to produce the succession certificate. A second suit was filed by him as manager of mutt. Okay. The second suit will be barred by res judicata. Will not be barred.
Suit brought by a person to recover possession from stranger. It was dismissed on his failure. What is succession certificate? Second suit was filed by him as a manager. What is the answer? Second suit will not be barred.
Res judicata under section 11 applies only where the matter directly and substantially in issue has been heard and finally decided between same parties litigating under the same title. In the first suit, the plaintiff sued in his personal capacity as heir of the deceased mahant.
Now he's
and the suit was
this one as a manager. So he is a manager.
Yeah. This is actually a real world case.
Oh no.
Okay. State of UP versus Nawab Hussain 97-7 case relates to constructive res judicata. Nawab Hussain. Constructive res judicata. Section 13. 13 God. Section 11 rule 4. Section 11 rule 4. Explanation 4. All right. Moving on. Appeals. Okay, the right to appeal is a statutory right. It exists only when specifically granted by a statute. There is no inherent or natural right to appear under common law. AIBE has tested this directly. Right to appeal is a statutory right, not a fundamental or natural right. This means an appeal lies only where a statute provides for it. The conditions, period of limitation, and procedure for appeal are governed by statute. There is no common law right of appeal independent of statute. The statute provides it. No condition, period of limitation, governed by statute. There is no common law right of appeal independent of statute. Okay. First appeal. Section 96 of CPC. Appeals from original decrees An appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. Key features. First appeal is on question of both fact and law. No restriction of substantial question of law. Okay. Appellate court has wide power to reappreciate evidence in first appeal. Okay. Limitation. 90 days for appeal to High Court, 30 days for appeal to subordinate court. Limitation Act. Must be from an original decree, not an interlocutory order. Okay. Those go under section 104. Okay. Second appeal, section 100 of CPC. Second appeal. The second appeal lies to the High Court from an appellate decree passed by a subordinate appellate court. Scroll down.
Coming, boss.
It's not an appeal from the High Court. Okay. A second appeal lies to the High Court from an appellate decree passed by a subordinate appellate court. Okay. Conditions for second appeal strict. Lies only on a substantial question of law, not on the questions of the fact. High Court must formulate the substantial question of law at the time of admission. After 1976 amendment, the High Court cannot examine findings of fact in second appeal. High Court cannot re-examine findings of fact in second appeal. Okay. The judgment in the second appeal must address the formulated questions of law. Okay, formulated question of law. So the statement second appeal can be on a question of fact or law or both is incorrect under section 100. Second appeal is restricted to substantial question of law alone.
Only law judge, no findings of fact. Second appeal. 100.
Okay. Appeals from orders.
Difference between appeal and revision?
Appeal is on higher court. They can reappraise evidence and all. Revision is just just to check whether this procedural correctness is followed or not.
Re-examining the same thing, I think.
Appeal is completely re-examining everything, witnesses and everything. Revision is just reviewing the judgment. Checking the judgment whether it is procedurally correct or not as per law.
ఇప్పుడు డిశ్చార్జ్ పిటిషన్ వేసినప్పుడు రివిజన్ వేస్తారు. ఓకే, వై ఇట్ ఈస్ నాట్? ఇప్పుడు ఫర్ ఎగ్జాంపుల్ ఇప్పుడు అరవింద్ కేజ్రీవాల్ ఇస్ డిశ్చార్జ్డ్. యు నో వాట్ ఎ డిశ్చార్జ్ ఇస్, రైట్?
Discharge from the what about
basically
allegations, huh?
So you don't know what discharge is. Basically what happens is when a case is filed, charge sheet is filed, before framing of charges, the judge can look at the evidence and the facts without conducting a trial, and he can say whether the case is fit for a trial or not, and that is called discharge. Okay, so Arvind Kejriwal, lower court said he is discharged. Now he has gone to High Court and filed a revision petition. Who has filed a revision petition? The CBI has filed a revision petition. Why they didn't go for appeal?
Can you please tell discharge once again, please?
Okay.
Discharge.
So discharge is basically, in a criminal case, what happens is, like, the police first gives after the complaint FIR is filed, right? So the police does investigation, collects evidences, witnesses, and gives a charge sheet to the court. From there on, the court takes over the case and the charge sheet is filed, right? So when the charge sheet is filed, the accused has a chance of filing a discharge petition. Okay, discharge petition లో ఏమవుతుందంటే, సార్ ప్రైమా ఫేసి అసలు కేసే లేదు, వై వీఆర్ వేస్టింగ్ టైమ్ ఆన్ ద ట్రయల్, ప్లీజ్ లుక్ ఎట్ ఇప్పుడు వాట్ ఎవర్ డాక్యుమెంట్స్ ద police can give, they gave everything away, right? So once the charge sheet is filed, you cannot have new evidences or new documents into it. So the role of investigation is over. So look at all the documents, and I feel that based on whatever documents are available, there is no case here. So the court will look at all the documents, everything, and they will also hear the arguments. It's like a mini trial without the witnesses or witness statements or whatever. And based on the face of it, if the court feels that the trial, whatever evidence is given, it is not up to the mark or the trial is not needed, that person is discharged. Okay.
Oh, okay.
So what in Kejriwal case, he was discharged from the case, which is like CBI and ED put. Okay. One case. In one case, he was discharged. So discharge అయినప్పుడు, what will the CBI do? CBI higher కోర్టులో, డిస్ట్రిక్ట్ కోర్టులోనో వేరే కోర్టులోనో, దే విల్ ఫైల్ ఎ రివిజన్ పిటిషన్. బట్ ఇప్పుడు నీకు డిశ్చార్జ్ అయితే, వాట్ యూ హ్యావ్ టు డూ? యూ హ్యావ్ టు గో ఫర్ అన్ అపీల్.
So
Right?
it's
Why
not
they have gone
finalized. No,
for
the trial is not done. The judgment is not given. Based appeal will go on a decree. So it is not a decree kada. Discharge
డిగ్రీ?
petition.
డిగ్రీ ఉంటే అపీల్, డిగ్రీ లేకుంటే అపీల్ కదా?
సో లోవర్ కోర్ట్ ఇచ్చిన జడ్జ్మెంట్ ని ఛాలెంజ్ చేయడానికి అపీల్కి వెళ్తాం కదా. ఇక జడ్జ్మెంట్ ట్రయలే జరగలేదు కదా.
ఈ అపీల్ వర్సెస్ రివిజన్ అనేది ఈజ్ అ వైవా క్వశ్చన్. ఓకే.
ఓకే.
ఇట్స్ అ వైవా క్వశ్చన్. సో బేసికలీ వాట్ ఈస్ ద డిఫరెన్స్? సో హైయర్ కోర్ట్కి ఇప్పుడు ఒక నాకు కింద కోర్టు నచ్చలేదు, నాకు నేను పై కోర్టు పోయినా, నేను పై కోర్టు పోయినప్పుడు రివిజన్ వేయాలా, అపీల్ వేయాలా?
సో ఇఫ్ ఇట్ డిగ్రీ ఈస్ నాట్ ఇన్ యువర్ ఫేవర్, యు విల్ గో ఫర్ అపీల్.
When a decree is
not in your favor, you will go for an appeal.
Okay, so when your decree is not in your favor, what will the other party do?
Other party would not do anything because it's in his favor కదా.
ఓకే. సో లాంగ్ స్టోరీ షార్ట్ ఏంటంటే, ఇప్పుడు ఈ డిస్కషన్ ఇప్పుడు నువ్వు హైపోథెసిస్ చెప్పి నేను చెప్పి పొద్దుగాలవుతుంది. పాయింట్ ఏంటంటే, జస్ట్ రిమెంబర్ దిస్, దట్ అపీల్ ఈజ్ ఎ లీగల్ రైట్. ఓకే. నీకు కింద కోర్టులో నీకేమైనా అన్యాయం జరిగితే, అపీల్ ఈజ్ యువర్ లీగల్ రైట్, విచ్ ద హయ్యర్ కోర్ట్ కెన్ నాట్ సే దట్ అపీల్ నేను తీసుకోను అని. సో అపీల్ ఈజ్ ఎ లీగల్ రైట్ to ask a higher court to re-examine the facts and the law to overturn a decision. Okay? Remember that.
Facts and law. Okay.
It is the legal right.
Legal right.
Whereas revision is discretionary review by higher court. It is not a legal right. It is a discretionary review by higher court, usually limiting to correcting serious legal or procedural errors. Okay? So appeal is rehearing, revision is supervisory check. నువ్వు కోర్టుని వెళ్ళి సూపర్వైజరీ చెక్ చేయమని నీకు లీగల్ రైట్ లేదు. నువ్వు ఇట్ ఈస్ బేస్డ్ ఆన్ ద డిస్క్రిషనరీ రివ్యూ ఆఫ్ ద హైయర్ కోర్ట్. అర్థమైందా?
So if they want, they'll see, or if they don't want, they will not continue.
Exactly. So it is a right versus discretion.
Okay.
చెప్పండి చాలు. Okay. So you're correct, Mahisha. Revision is basically to correct irregularities or improper procedures.
Okay.
And appeal is to change the judgment or a decree.
Okay.
Okay. Sorry. Let's move on.
Okay.
So we're talking about appeals కాబట్టి చెప్పినా నేను.
Okay.
We learned something new. Thank you.
Okay. It's not new, but we didn't focus.
Okay. Thank you అంటే చెప్పకరా, వాళ్ళు ఫీల్ అవుతుంది.
Thank you for letting us know.
బాధ అదే కదా.
చెప్తున్నా మేము చదవలేదని చెప్తున్నా.
Okay.
ఇంత ఫోకస్. సరే. Appeals from orders.
Come read. Chalo. Or else I'll feel sleepy inka.
Okay. Certain interlocutory orders can be appealed even before final judgment. Okay. Interlocutory orders. Okay. Appealable interlocutory orders under 43 Rule 1 illustrative order granting or refusing temporary injunction under 39 CPC. Okay. temporary injunction 13 CPC, order rejecting plaint under Order 7, Rule 11. Okay, order regarding pleading amendments, Order 6, Rule 17. Okay. Orders under Order 38 CPC, attachment arrest before judgment. Order under 9, setting aside ex parte decree. Okay, only orders specifically listed in Order 43 Rule 1 are appealable. It is not an open-ended list. Okay. Okay, only under 43. In order not listed, they cannot be appealed under Section 104. Only these orders can be appealed. Okay. Okay, moving on. Procedure
L
of
అంటే
appeal.
50 కదా?
Yeah, L అంటే 50. ఏమైంది ఇప్పుడు?
ఏం లేదు 43 ఉన్నావు. ఓకే సరే.
సో వెనకాల ఉంది కాబట్టి మైనస్ చేయాలి కదా.
ఓ యా కరెక్ట్.
సో procedure of appeal 41. Memorandum of appeal filed with affidavit and certified copies of judgment or decree. Application for stay of decree. Stay of execution must be applied for separately. Okay. Notice to opposite party. Appellate court may affirm, reverse, or modify the judgment. Appellate court may order retrial on specific issues. Okay. Stay of decree by appellate court. Order 41, Rule 5, CPC. When an appeal is preferred against a decree, the appellate court may stay the execution of decree. The appellate court, not the executing court, has the power to direct the court that passed the decree to take security when an execution order is challenged on appeal. Exam tested under. Okay. Preferred against the appeal court. Okay. Purpose of appellate court 41 rules 23 to 33. Review all findings of facts and law in first appeal. Order 41 Rule 25, where any issue has been wrongly omitted or has not been determined by the trial court, the appellate court may frame the issue and remit it to it for trial to the lower court. Okay. Admit new evidence if justice requires. Limited scope under Order 41 Rule 27. Award interest on decretal amounts. Award costs of appeal to successful party. Okay. Supreme Court's appeal. Special rules. The rules framed by the Supreme Court under Article 145 of the Constitution regarding appeals are a special law that prevails over the CPC provisions in respect of appeals to the Supreme Court. Hence, none of all of those similar to CPC, etc. Option is correct on this. Answer none of this. Okay. Exam tips. Right to appeal, statutory right, not inherent or natural. Section 96. First appeal from original decrees. On fact and law, appellate court can reappreciate the evidence. Section 100 would be second appeal only on substantial question of law, not fact. Next. Second appeal, High Court must formulate substantial question at admission stage. Rajesh Kumar Agarwal case. Section 104, read with Order 43, Rule 1, appealable interlocutory orders, closed list. Okay. Order 41, appellate procedure. Order 41 Rule 5, appellate court, not executing court, has power to stay execution and direct security. All right. 41 Rule 25, appellate court may remit issues for trial to lower court. Okay, remit issues for trial to lower court. 41, admission of new evidence in appeal, limited grounds. Okay. 27, Supreme Court rules Order 145 prevail over CPC for Supreme Court appeals. Okay. Questions? Which of the following statement is incorrect? First appeal can be on question of fact or law, both. Yes. Second appeal can be substantial question of law only. Correct.
C is the answer.
Second appeal can be question of both. Okay, right. C is the answer. As per section 100.
100.
This is second appeal.
Only on question of law.
What is 104?
104 పైనే ఉంది కదా. అపీలబుల్ ఇంటర్లాక్యుటరీ ఆర్డర్స్ అంట.
43.
43 తెలియదు నాకు.
Section 104 read with 43. Order 43. Order 43 contains the list of appealable interlocutory orders.
ఓకే.
Okay. 41 is the procedure.
ఒక ఇంటర్లోకిటరీ ఆర్డర్ ఎగ్జాంపుల్ చెప్పు.
Temporary injunction.
కరెక్ట్. నా ల్యాండ్ మీద రావద్దు, యూ కెనాట్ కమ్, నా బిల్డింగ్ లోకి రావద్దు అన్నప్పుడు ఆ ఇంటర్లోకిటరీ ఆర్డర్ కూడా అప్పీల్ చేసుకోవచ్చు.
Okay. Scroll down for next question. Question 2. Question 3, I think. Yeah. Okay, question 2. Under which of the following provisions of the Civil Procedure Code the appellate court may remit an issue for trial to the lower court? 41 Rule 25. Appellate court where it appears that any issue has been wrongly omitted or has not been determined to frame the issue and refer the same to trial court for lower court, same for trial, whatever. 24 final disposal by appellate court itself. Okay. Which section of the CPC allows for the appeal from original decrees? 96 first appeal. Okay.
100 is second appeal, no?
So okay, so first appeal మీద second appeal వస్తుంది. So first appeal original decree, right? All right. Okay. According to the CPC 1908, who can direct the court that passed the decree to take security when an execution order is challenged in an appeal?
Can direct the court. Who can direct? Appellate court. Pass the decree to take security when an execution order is challenged in the appeal. Appellate court hearing the appeal.
Under 41 Rule 5, appellate procedure. When an appeal is preferred against a decree, an appellate court may stay the execution of decree.
సో ఇట్ ఈస్ ఇంత ఇంగ్లీష్ కాకపోయినా సింపుల్గా చెప్తా. ఒక ఎగ్జిక్యూషన్ ఆర్డర్ ఎవరైతే మనం ఏ కోర్టు అయితే ఇచ్చిందో ఆ కోర్టు ఎగ్జిక్యూషన్ ఆర్డర్ ఆ కోర్టుకి వెళ్ళాలి మనం. వేర్ యూ హ్యావ్ అపీల్డ్ ఓన్లీ యూ హ్యావ్ టు గో.
Okay. Who can direct the court that has passed the decree to take security when an execution order is challenged in an appeal?
The court which is hearing the appeal is the correct answer.
Who can direct the court that passed the decree? Okay, appellate court would direct the lower court to execute. Is it?
Hello.
Yeah.
Mahesha, చెప్పు.
So appellate court would direct the lower court to execute or take security, whatever. Appellate court would not do that. I mean,
Correct.
Okay. Which of the following is true of rules framed by the Supreme Court with reference to appeals to it? Okay. There are special law within Section 4 of the Code of Civil Procedure. They must take precedence over Section 114 or Order 47. A and B and none of this. So we have read that Supreme Court under Article 145 of the Constitution regarding appeals are special law that prevails over CPC provisions. So you could ichna sections tappu. So none of the above.
Okay.
Option A states that the special law within Section 4 of CPC is partially correct in effect, not precisely stated. Section 4.
Okay. Supreme Court doesn't require to take any precedence.
It is a very tough question.
Okay. Right to appeal is a which right?
Right to appeal is a legal right. Statutory.
Right to revision. Right to submit a revision.
Discretionary.
Good. All right. Next
ఈ
section would
నాలెడ్జ్
be
చూసి మేడం అక్కడ ఫెయింట్ అయిపోయి ఇట్లా నురగలు కక్కేసుకుంటాం మహేష.
అంటే ఆల్రెడీ హేమాలి అప్పుడే ఫెయింట్ అయిపోతుంది. నా వరకు కొత్త వాళ్ళు వస్తారో రారో ఇంకా.
హేమాలి బాగా చెప్తుంది ఆన్సర్, నువ్వే.
సరే. These are three distinct mechanisms by which, okay, reference, review, and revision. These are three distinct mechanisms by which judgment and orders can be re-examined, but they have different scope, procedure, and forum. Okay, reference is mentioned in section 113 of CPC. A subordinate court may, on its own
నేను
motion
చదవనా?
or ఎందుకు?
If you
Sir,
want me to.
sir, I
Yeah,
started this. No, let me continue.
Okay, continue.
I don't want to leave anything in the middle.
ఓకే బ్రో, ఓకే, గో హెడ్ ప్లీజ్. 19 టాపిక్స్ ఉన్నాయి, 13 మేడం.
Okay. A subordinate court
లాస్ట్
may.
టాపిక్ వదిలేస్తాను లాస్ట్ లో. Read
Next
the
topic
rest.
is the subordinate
వద్దు,
court
please.
may, on its own motion or on the application of a party, refer a question of law for the opinion of the High Court. For the opinion, okay. A reference, okay. All right. They are asking questions to High Court, clarifying doubts. Ante kada. Reference ante.
అంతే. For a question of law.
Conditions for reference.
Conditions ఏంటి?
The point of law must arise in a suit pending before the subordinate court. Okay. ఏది పడుతుందానికి లేదు, it should be in a suit. The subordinate court must have doubt about the question of law, specifically doubt as to the validity of any act, ordinance, or regulation, or a question of construction. The point relates to interpretation of statute or important question. Okay. Okay, interpretation of statute for important question. Okay. Reference is suspended pending the High Court's opinion. Okay. All right. Pending the High Court's opinion.
Reference is suspended pending the High Court's opinion. అదే
So
High Court
when High Court is
opinion.
not reverted, then before the reversal, we can before the revert, we can cancel the reference.
Pending the High Court's opinion అంటే
రిఫరెన్స్, యా.
So we have referred, they haven't responded yet, so we are cancelling.
క్యాన్సిలింగ్ అది సస్పెండింగ్.
అంతే కదా, రెండు మీనింగ్ ఆల్మోస్ట్.
సస్పెండింగ్ ద
రెండు అది
రిఫరెన్స్,
కాదు,
సస్పెండింగ్ ద
రెండు
కేస్.
డిఫరెన్స్ ఉంటుంది.
Reference is suspended.
ఓకే.
So reference is by subordinate court referring the case to High Court for its opinion. Exam tested, not vice versa, not partially, initially independent of the court. A reference can be made during the pendency of the case for the High Court's opinion on a question of law. Okay. Next would be review. Section 114, 113, 114, 115 gochu. Okay. Order వచ్చి 47. Okay. Section 114 CPC read with order 47, rule 1. Any person considering himself aggrieved may apply for a review of judgment to the same court which passed the judgment. By reason of grounds for review would be under 47 rule 1. Discovery of new and important matter of evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced at the time of the decree. Okay, next. Mistake or error apparent on the face of the record. A decree that contradicts settled. Okay. A decree that contradicts a settled point of law. Okay. Mistake or error apparent on the face of the record. Okay. C vachi any other sufficient reason interpreted narrowly must be analogous to the above grounds. Chajuram versus Neki 1922 PC restricted sufficient reason to grounds analogous to A and B. Okay.
Okay. So in Kejriwal case, Kejriwal was basically discharged. He cannot say acquitted because it was not a trial. So discharge అయిపోయిండు. So CBI put a review petition, right? Under what grounds did they put?
Mistake or error apparent on the face of the record.
Yeah, or they can say it has been interpreted very narrowly. Okay.
Okay. So this is review, no? That is revision.
Sorry. This is review. Review is only the same court. Only డబ్బులు ఎక్కువైనా.
Okay,
Correct.
procedural. Okay.
అంటే ఇప్పుడు జడ్జిమెంట్ లో 5 lakh, ఇప్పుడు ప్రొనౌన్సింగ్ 5 lakhs చెప్పి జడ్జిమెంట్ లో 5,000 వచ్చింది అనుకో, they can go for review.
Okay.
It's the same
Note.
court.
Yeah. Judgment against the weight of evidence is not a ground for review. Against the weight of the evidence. Okay. This is a common AIBE trap. Such errors must be challenged on appeal, not review. Okay. To reappraise the evidence.
Weight of evidence ante?
So evidence is not considered much. I mean, I think. So to reappraise the evidence, we have to go for appeal.
So if you feel that whatever evidence is given, ఆ ఎవిడెన్స్ ఉన్నా కూడా జడ్జ్మెంట్ అగేన్స్ట్ వచ్చింది అని సేమ్ కోర్టులో అపీల్ చేయలేం, పైన కోర్టులో చేసుకోవాలి.
Okay. Categories of persons who seek review. A person aggrieved by a decree or order from which an appeal is allowed, but no appeal has been preferred. Appeal has been preferred. Okay. A person aggrieved by a decree or order from which no appeal is allowed. Okay. So what kind of decrees where no appeal is allowed?
స్పెసిఫిక్ గా రాస్తారు కొన్ని డిగ్రీలో నో అపీల్ అలౌడ్ అని, బికాస్ ఇట్ విల్ గో ఆన్ ఫర్ ఎవర్ అని.
Okay. A person aggrieved by a decision on a reference from a court of small causes. Okay. Okay.
సమన్స్ కేసులో
He's not.
చిన్న చిన్న సమన్స్ కేసులో అపీల్ కూడా అలౌ చేయరు.
Yeah.
ఇప్పుడు నీకు డ్రంక్ అండ్ డ్రైవ్ కేసు ఉంది, అందులో నువ్వు నీకు 1 day జైలు వేస్తారు కదా.
ఓకే.
నేను అంటే నీకు కాదు జనాలకే, ఆర్ 10,000 ఫైన్ వేస్తారు కదా, ఆ 10,000 మీద యూ కెనాట్ గో ఫర్ అపీల్.
ఓకే. కండిషన్స్. అప్లికేషన్ జనరలీ విత్ ఇన్ 30 days ఆఫ్ జడ్జ్మెంట్. నాకు ఈ డ్రంక్ అండ్ డ్రైవ్ సంగతి పక్కన పెడితే నాకు గుర్తుకొచ్చింది ఏంటంటే, ఈ సైబరాబాద్లో పార్కింగ్ అఫెన్సెస్కి 1,000 రూపీస్ ఫైన్ వేస్తారు, హైదరాబాద్లో 100 రూపీస్ ఫైన్ వేస్తారు. వై ఈస్ దిస్ డిఫరెన్స్ అండ్ కెన్ వి ఛాలెంజ్ ఇట్? పిఐఎల్ వేయాలా? మరి ఇన్ని రోజులు ఎవడు ఎందుకు వేయలేదు అసలు? ఎప్పటి నుంచో ఉన్నాయి.
ఓకే, ఫోకస్. నెక్స్ట్.
Conditions of review would be application generally within 30 days of judgment. Court must consider whether case would be different based on new ground. Court must consider whether case would be different based on new ground. Okay. Court may call for files, hear arguments, and modify the judgment. Okay. Court willfully can do it. Okay. Okay. Next, 115 revision. Section 115 CPC revisional jurisdiction of High Court. The High Court may call for the record of any case decided by a subordinate court in which no appeal lies, and pass such order as it thinks fit if it appears to the High Court that the subordinate court. Okay, if we apply for a revision, High Court would take the call. We don't need to do anything. It's their discretion to call for records or whatever. Okay. Statutory grounds for revision would be exact language. Has exercised the jurisdiction not vested in it by law. Okay. High Court is in the writ of certi or aria. Has failed to exercise a jurisdiction so vested. Has acted in the exercise of its jurisdiction illegally or with material irregularity. Okay. Material irregularity means procedural errors.
ఇది నిన్న కూడా చదివాం కదా, మెటీరియల్ ఇర్రెగ్యులారిటీ.
Yeah.
Important. Fraud, natural justice, etc. are not statutory grounds under section 115. Not statutory grounds. Fraud. The grounds are strictly jurisdictional and procedure. So if it is fraud, we should go for appeal. Huh? Okay. The word case in section 115 is of wide import. It includes civil proceedings other than suits and is not restricted to anything contained in the section to the entirety of the proceeding in a civil court. Okay. When revision is not available, it includes civil proceedings other than suits and not restricted to anything contained in the section. Okay. When revision is not available, when an appeal lies, revision is not maintainable, party must appeal instead. Okay. Where the lower court's order is on a question of fact. Okay. Only for law-related procedural errors, we can go for revision. On facts questions, it's not possible. Okay. Where the subordinate court's order is purely a procedural error, not involving jurisdiction. Okay. Okay. Scroll down. Down. బాగా స్క్రోల్ అయిపోయింది ఇంకొంచెం పైకి. So the answer to in which case the remedy of revision is not available is all of the above. Okay.
All of them. ఎక్కడ ఏం చదువుతున్నారా భయ్ నువ్వు?
వెయిట్ చేయి కంగారు పడుకో. సో ఇక్కడ ది 3 ఆప్షన్స్ ఇచ్చాడు కదా, ఇఫ్ ఇన్ ఎనీ క్వశ్చన్ ఇఫ్ ఆ 3 ఆప్షన్స్ వస్తే ఆల్ ఆఫ్ ది అబౌవ్ పెట్టాలని ఇక్కడ ఎవరో రాశారు.
ఓకే. శివాన బచ్చగాలు రాసింటారు.
అంతే. When the listed cases include where appeal lies, where order is on a question of fact, where there is no jurisdictional error. Okay, where appeal lies, where the order of question of fact, where the jurisdictional error. Okay. Nawabganj Sugar Mills versus Union of India 1976 under section 115, the High Court can only interfere on jurisdictional grounds, not reappreciate evidence or substitute its judgment for that of the trial court. Section 115 revision is limited and narrow. Only jurisdictional grounds లోనే రివిజన్ అవుతుంది, మిగిలినంతా అపీల్ చేసుకోవాలి. Okay, they've listed out the differences. So here appeal is in high court. Appeal is only in high court or any higher court then?
హయ్యర్ కోర్టే ఉంది అక్కడ.
హయ్యర్ కోర్టే ఉందిరా నాయన. నువ్వు చదివేది లేదు నిన్న. ఇఫ్ ద కేస్ ఇస్ ట్రయబుల్ అంటే ట్రయల్కి వెళ్ళేది. ఇఫ్ ద కేస్ ఇస్ ట్రైబల్ అని చదివాను నేను.
ఓకే, తెలుగు మీడియం నేను అందుకే. ఓకే, రివ్యూ వుడ్ బి ఇన్ సేమ్ కోర్ట్ దట్ పాస్ జడ్జ్మెంట్. యా, నేను తెలుగు మీడియమే 10th వరకు.
But you speak English quite well.
Yeah, I've learned it by watching movies.
Oh yeah?
Yeah.
Yes, you learned the language.
నాకైతే డౌట్ అబౌట్ ఇంగ్లీష్ మీద, బట్ లెట్స్ మూవ్.
అంటే బట్ ఫ్రమ్ తెలుగు మీడియం ఇట్స్ స్టిల్ క్వైట్ డిఫికల్ట్.
ఈ స్టిల్ స్పీక్స్ లైక్ తెలుగు మీడియం గై ఓన్లీ.
కానీ మ్యాథ్స్ లో మీకు ఏదో ఉంటాయి కదా, ఏవో ట్రిగ్నోమెట్రీని ఏదో వేరేగా.
అంతేం గుర్తులేదు 20 అయిపోయింది కదా, 10th అయిపోయి గుర్తులేదు నాకేమి. ఐఎమ్ బైపీసీ స్టూడెంట్.
అవును, బట్ దట్ ఈస్ ఇన్ ఇంటర్ రైట్? ఓకే, లీవ్ అబౌట్ యువర్ దిస్ వన్.
ఇది 2026. మై 10th class was in 2002. 24 years అయింది. ఇంకేం గుర్తుంటాయి అవి. ఓకే, లెట్స్ కంటిన్యూ.
మహేష 19 చాప్టర్స్ ఉన్నాయి మహేష. 12th లోనే ఉన్నాం ఇంకా.
ఓకే, హైకోర్ట్ ఓవర్ సబార్డినేట్ కోర్ట్. ఓకే, రివిజన్. Okay, grounds error of law or fact, new evidence, error apparent, sufficient reason, jurisdictional error. Okay, ఇది అవసరం అసలు. Section 96, 114, 115, 113 వచ్చి reference. Scope, re-examination on merits, reconsideration on same record, limited to jurisdictional grounds. When available, when statute provides, when no appeal preferred or no appeal lies, when no appeal lies, whatever. Okay. All right. Move on. Clerical errors, section 152. Okay. Section 152 CPC specifically provides the clerical or arithmetical mistakes in judgment, decrees, or orders or errors arising from any accidental slip or omission may at any time be corrected by the court either on its own motion or on the application of any party. So clerical or arithmetical are corrected under section 152. Okay, not under section 114. 114, which would be review. Okay. Exam tested. Section 113 exam tips. Order 46. Reference subordinate court refers question of law to High Court. Okay. Section 114 plus order 47. Review. Same court which passed the judgment. Review grounds 47 Rule 1. In new evidence with due diligence, error apparent on face of record, any other sufficient reason narrowly construed. Judgment against weight of evidence is not a review ground. Review available where no appeal preferred, no appeal lies, decision on reference from small causes court. Section 115, revision High Court over subordinate courts only on jurisdictional grounds. Section 115 grounds would be jurisdiction exercise when not vested, fail to exercise, or illegal exercise. Okay. Move on. Move on, please. Trigonometry ni trigonometry antaru. Trigonometry.
I moved on, bro.
Okay. Case in section 115 has wide import, covers all civil proceedings, not just suits. Revision not available where appeal lies. Nawabganj Sugar Mills, section 115, revision limited to jurisdictional errors, cannot reappreciate evidence. Okay. Section 152 would be clerical or arithmetical errors corrected by.
Sir కూడా వెళ్ళిపోయారు.
Yeah. Okay.
నిద్ర వస్తుందారా?
I think energy పోయింది.
Okay.
Energy has reduced. Okay.
Energy is right.
Let's finish the questions at least. Okay. The word case used in section 115 of the Civil Code of Civil Procedure is of wide import and it includes civil proceeding, other suits, and is not restricted to anything contained in this section to the entirety of the proceeding in a civil court. Okay.
Word case, section 115 CPC is wide import. Includes civil proceeding, not restricted to anything contained in this section to the entirety of the proceeding in a civil suit.
Alrighty.
Wide import proceeding. It's not basically it's not restricted only to suits. Okay.
Yeah.
Jurisdiction extends to all civil proceedings.
It includes civil proceeding, other suits, and is not restricted to anything contained in the section to the entirety of the proceeding in a civil court. Okay.
Option A alone is correct, anta, but it's not complete. It means that any state of facts option C, A, and B might seem right, but the key marks. Okay. Option D is none is wrong because B correctly describes the wide import. That means other options also may be correct, but we have to choose the most
suitable.
Most suitable. Chala correct ga untene okay. Sir, next one is reference made during the pendency of the case.
The subordinate court refers the subordinate court.
Wait, I'll read it. A reference can be made during the pendency of the case when subordinate court refers the case to the High Court for the latter's opinion on a question of law. Subordinate court reference can be made during the pendency of a case when the subordinate court refers the case to the High Court for the latter's opinion and the High Court's opinion on a question of law. 113.
Interpretation of statute.
Interpretation of statute, ordinance, something. No, they had doubt.
Yeah.
Validity, regulation, blah blah blah. ఓకే, అదేంటది 113. ఓకే,
Yes.
సెక్షన్ 113.
Reference is
Reference can be
113,
made.
review 114, revision 115 sequence.
Subordinate court to higher court for the opinion, for higher court's opinion. Third one is question 3. A person can apply for a review of judgment when
Jurisdictional
he's
error.
aggrieved unnado, aggrieved by decree or order from which appeal is allowed, but no appeal has been preferred. B is he's aggrieved by decree or order from which no appeal is allowed.
Can you
Okay,
scroll
small
up?
causes. All of the above. All of the above.
There is question repeat like. Okay. Okay.
Okay, a person can apply for review of judgment when all these three, when aggrieved by decree of order, when for which an appeal is allowed but no appeal has been preferred, when no appeal is only allowed, and court of small causes. ఇదంతా 114 లో ఉంది, section 114. Okay. Then next one, question 4. In which of the following cases the remedy of revision is not available? Cases in which first appeal lies, cases in which second appeal lies, interlocutory orders, all of the above. Remedy of
Interlocutory
revision
orders.
is not available.
Case in
Not
which first appeal
available is
lies.
all of the above. All of the above is the answer. Okay. Section 115 CPC confers revision jurisdiction on the High Court only against orders by the subordinate courts in cases where no appeal lies, and only in respect of jurisdictional errors. Revision is therefore not. Three conditions you, that one only, some three conditions you were telling. Fine, ekkada undedi kada. First appeal lies, second appeal lies, or C, after 1999 amendment against interlocutory orders that do not finally dispose of the case. Hence D, all of the above. You have to remember this. Sorry. Shall I go to the next one, or anybody wants to add or read or anything?
నాకైతే ఓపిక అయిపోయింది. విల్ డూ టుమారో. యా,
Okay, done.
Finish the question. No? Questions are nahi ka.
సరే, క్వశ్చన్ లో అవగొడతాం. ఎగ్జిక్యూషన్
ఒకటే
Last
question ఉంది.
question only. Last question. Okay.
152 clerical arithmetic mistakes.
5 clerical or arithmetical mistakes in judgments, decrees, or orders can be corrected under section 151, 152, 152. Answer is 152 CPC specifically provides that clerical or arithmetical mistakes in the judgments, decrees, or orders arising from any accidental slip or something
So
may
we
at
need
any
to
time be
submit an
corrected by the
application.
court.
So we need to submit an application to the court again for clerical mistakes.
On its own motion or on application. Option A and T 151 is the broader inherent powers provision. Option C is 153 deals with amendment of records. D ante 153A relates with amendment after appeal. So 152 is specific provision for clerical and arithmetic errors. Various options kuda manaku teliyali. Broad inherent powers okati, 152 is clerical and arithmetical mistakes, 153 deals with amendment of records, and 153A is అది కూడా amendment కానీ amendment after appeal. Okay, we'll do tomorrow.
ఓకే, ఆల్ రైట్. Thank you, guys.
47.
విల్ డూ ఎగ్జిక్యూషన్ ఆఫ్ డిక్రీస్ టుమారో. 13 నుంచి ఇంకా 19 ఉన్నాయి. సో ఎనీవే దిస్ థింగ్స్ విల్ గో స్లో బికాస్ ఫస్ట్ 4 టాపిక్స్ ఆర్ వెరీ ఇంపార్టెంట్ కదా. ఆఫ్టర్ దట్ సెక్షన్స్ లో ఎక్కువ క్వశ్చన్స్ లేవు, 20నే ఉన్నాయి విచ్ వీ కెన్ ఫినిష్ ఆఫ్. లైక్ వీఆర్ డూయింగ్ 20-25 every day, right?
Yes.
So let's focus on what is important.